The committee meeting, as ever, will be recorded and broadcast throughout Parliament buildings and online. It's proposed that the oral evidence sessions with the Probation Board and Niakro on the Justice Bill recorded by Hansard. Are members agreed? Thank you. Members, as ever, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approaches to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises in the course of the meeting. Does anybody have any interest they wish to declare at this stage? Danny?
Yes, I have an immediate family member who works for the Probation Board.
Thank you. I have an immediate family member who works in the legal profession, and a number of us are members of the APG on access to justice. That's us, isn't it? Mm-hmm. Okay. Members, if I can ask you to turn your attention, agenda item 1 is apologies, just to flag up to you that we have apologies from Doug, Stephen and Morris, who's going to be late. Morris should be with us about 2:30. And I presume then he'll also be joining virtually. And I see that virtually we've got the Deputy Chairperson Deirdre Hargay and Justin McNulty. Agenda item 2 is the draft minutes of the meeting held on Thursday the 1st of May. Those are pages 5 to 16 of your meeting pack. Are you content that those minutes are a true and accurate reflection of the proceedings of that meeting on the 1st of May? I just have one thing I want to flag up. If I could ask you to turn to page 9. And it is the second bullet point down where it's recorded that we asked the department to comment on the appropriateness of conducting consultations over the summer period. I think it was less about asking them to comment on the appropriateness and perhaps expressing our concern. If the department had concerns over the appropriateness, it probably wouldn't do it. So it's not about asking them to comment on it, it's just saying, look, you know, it's a worry for us that they do that and to bear it in mind. So could I ask that would members be content if that bullet point was changed to reflect the discussion? Yeah. Content? Yeah. Yeah, great. Well, thank you very much. And once that's amended, then I'll sign the minutes. Agenda item 3 is matters arising, and I would ask you to turn to pages 18 to 20 of your pack. Just to remind you that there's a note of the informal meeting that was held with the Lady Chief Justice and judicial colleagues on Tuesday the 29th of April, and that's been included in the pack. The note's not intended to be a detailed summary of the discussions, but instead it provides a high-level overview of the issues that we discussed. Can I take your views on whether there are any matters you would like the committee to follow up with the Lady Chief Justice, the Department of Justice or any other relevant organisation, or if you're content to note the paper? The one thing that I would say is I anticipate that we will follow up and dig a bit deeper into this issue, as we've already agreed. We're aware that there are a number of further papers due to come from various people like the Ombudsman and HMIC and so on, and obviously the Cresswell review is underway, and I think that all of those things could feed I suppose our information on that and to help to direct our thoughts on it. But does anybody want to come in on this at this juncture? Connie?
If I could, Chair, I think the meeting was obviously very useful, but I think a lot of the issues that they raised that, when we had discussed are matters for the Department of Health, and I just wonder if there's anything that would be appropriate for us to do to follow up, especially thinking around things like the impact on the availability of social workers has on family court proceedings. And I just think if there's anything we can do in that sphere, I think it might be useful, but obviously don't want to step outside our remit as well.
I think obviously there's a huge amount of overlap there, and some of it is far from the control of the Department of Justice, or indeed the judges. We were due to have follow-up with the Committee for Health with regard to right person, right care. We had a joint session, I think it was November, but by the end of that we ended up in court, so we weren't able to make further decisions. But I think there does need to come a point where we do have another session with the Committee for Health. In the interim period, it may be worth us forwarding on that note, so that they're aware of the issues that were discussed and the impact that there is within the court system.
Yeah, obviously we're getting a lot of correspondence about it to the committee and people raising concerns, so yeah, if we want to keep them in the loop to give them assurances that we're taking it seriously.
Yeah, I think we can send it on. If they have any further issues they want to raise with us, they can do that, and then as you know, as we get maybe deeper into the issues, we can seek potentially a joint meeting. Members agree to that?
Yeah.
Thank you. Agenda item 4 then is the Justice Bill, and that takes us to our oral evidence session from the Northern Ireland Probation Board. Can I ask members to turn to pages 21 to 30 of your packs, please? Members, we have with us Amanda Stewart, who's the Chief Executive, Gillian Montgomery, who's the Director of Operations, and Aideen McLaughlin, who's an Assistant Director at the Probation Board. Ladies, you're very welcome. Thank you very much for taking the time to join us today. Usually what we do is we do a bit of housekeeping and we coordinate our questions in terms of subject matter, but your evidence is quite tight, so we'll just take members as they indicate. I'm going to hand over to you for maybe 10-15 minutes. If there's anything else you want to add, we've already had your written submission, and then I'll open to members for questions. Does that suit you all right? That's great, Amanda. Thank you very much. I'll hand over to you.
Thank you, Chair. Good afternoon, and thank you for the opportunity to provide evidence today as part of the proposed Justice Bill. As you can see, I'm joined today with Gillian Montgomery. Gillian is our Director of Operations and is responsible for our work in the courts and the community. And Aideen is an Assistant Director, has operational responsibility for North and West Belfast, victims, restorative justice and children and young people. And there's probably a few other things thrown in there, but that largely is it. I know members are familiar with the role of the Probation Board for Northern Ireland, but I'll just briefly set some context this afternoon and outline why the provisions in the bill are relevant to the Probation Board. As you know, probation works to protect the public and reduce reoffending by supervising people who have offended in the community, while also overseeing their rehabilitation and resettlement. We aim to provide an individual and trauma-informed approach that tackle the root causes of offending, and this can be different for every person who walks through our door. That person-centred and trauma-informed approach is particularly relevant in respect of our work with children and young people. All our practitioners have been trained in respect of adverse childhood experiences and trauma-informed practices, and we work closely with the Safeguarding Board for Northern Ireland in respect of continuing to develop this practice. We know that many of the young people entering the criminal justice system have experienced multiple adverse childhood experiences, including being the victim of sexual abuse, exposure to domestic abuse, and as a parent also having served a prison sentence. Therefore, as noted in the earlier evidence session by the Commissioner for Children and Young People, it is imperative that all professionals working with children and young people understand and take account of the impact of trauma while working to reduce reoffending and ultimately protect the public. In terms of probation's caseload, you will have seen from our written evidence that the vast majority of people that probation supervise are over the age of 18. It's only approximately 1% who are under 18, and just by way of context, that's probably about 40 individuals. It is absolutely right that the Youth Justice Agency is responsible for the supervision of children and young people sentenced to a community order, and we believe it would be beneficial for children to be supervised through a single community order, of which the Youth Justice Agency is the single supervisory body. This ultimately would prevent duplication and ensure that there is a streamlined and child-orientated process in place which will prevent reoffending and reduce the numbers of victims in the future. It is also important that any new community order is suitably flexible to allow for the relationship building between the child, the supervising officer, and where appropriate, victims, in order to increase their effectiveness. Whilst very small numbers of our caseload are under 18, approximately 15%, which is probably about 80, of our caseload is aged between 18 and 25. In this regard, some of the members will be aware that the Probation Board lead on the delivery of the Aspire Young Men's project, which was set up following the recommendation from the Fresh Start panel report on the disbandment of paramilitary groups in Northern Ireland. The aim of Aspire is to reduce criminality and risk-taking behaviour in young men aged 16 to 30 who are marginalised within their communities and at risk of becoming involved in paramilitarism. It is a collaborative project led by PBNI and is delivered in conjunction with the community and voluntary sector partners Niakro, CRJI and Northern Ireland Alternatives. The project has been evaluated and has proven to be effective in promoting positive outcomes for those young men who are presenting with multiple and complex issues, including addictions, poor mental health and lack of access to appropriate accommodation. We welcome the provisions within this bill in respect of the presumption of bail for children and young people. If they can be supported to safely remain in the community, we know that the outcomes for them will be much better. The ability to retain support networks and services in the community, including family ties, education and employment, are all factors which reduce the risk of further offending. Probation is supportive of the amendments to police and court bail that a child should not be placed in custody solely because of accommodation needs. Every effort should be made to seek appropriate accommodation and link with social services and others to prevent a child being placed in custody unnecessarily. Trying to secure appropriate accommodation for PBNI service users is a growing challenge for us in the organisation, and we understand that it impacts service users of all ages. It is, however, a real concern that due to lack of appropriate accommodation, some children and young people who have been granted bail have been unable to avail of it. As stated in our written evidence, we believe there is a need for all organisations to work together to address children's accommodation needs whenever they arise. Finally, I just want to say something about the impact of entering the criminal justice system can have on children and young people, and in particular the need to minimise stigmatisation and labelling very young people as offenders. It is important that our interventions and engagements with young people do not further stigmatise them, as we know this can lead to further exclusion, poor behaviours and reoffending. It is also for this reason that the PBNI supported raising the minimum age of criminal responsibility to 14 years, in line with recommendations in the United Nations Committee on the Rights of the Child. Children who enter the criminal justice system often present with very different needs and risks to the adult population, and it is important that all practitioners working with children are equipped to build effective relationships and provide evidence-based interventions which can break the cycle of criminality, provide hope to children and young people, and ultimately keep our communities safer. Thank you, Chair. I'm happy to take any questions.
Thank you very much, Amanda. Danny?
Thank you, Chair. Thank you. I just wanted to focus on the accommodation side of it. I'm just wondering what engagement you have had with the department themselves and the Minister.
Specifically on children and young people's accommodation?
Yeah, on the accommodation. I suppose I'm concerned about the fact that the Minister is not going to commence Clause 8.
I'll maybe turn to 18 in respect of, but just to give you a sort of a wider context in terms of just how challenging accommodation is becoming. We're increasingly finding difficulties within our own organisation, and actually even though there has been a lot of work done, particularly in relation to people coming out of custody into the community around accommodation, the nature of the people that we work with means that that breaks down very quickly. And actually what you might find is that the figures are very high for people coming out of custody with suitable accommodation, but within a number of days that breaks down, and that then presents challenges for our own staff. Certainly our board members had asked us to set up an accommodation working group, and we are doing some work internally to look at that and linking with the housing executive, but that's ultimately in respect of adults. I'm going to turn to 18 who'll be specifically linked in around the issues for children and young people, but I suspect when you have difficulties with adults that becomes even more challenging whenever you have children, and I suppose in a sense our concern here is that actually unless this is addressed it is going to become a problem.
Thanks, Amanda. I suppose kind of one of the pieces of work that the Probation Board was involved with jointly along with Housing Executive and the Health and Social Care Board was the review of jointly commissioned accommodation for young people from the ages of 16 to 21, and that was published in 2023, and it made a series of recommendations around how can we improve the pathways for young people who are both kind of coming through the care background and also those young people leaving custody. How can we ensure that the accommodation is in the right place and available at the right time and has the right resources around that to enable young people to succeed once they come out of care or of custody? So that publication was, I think, September 2023. Since then, there has been kind of a working group established along with the Housing Executive supporting people, Youth Justice Agency, Probation and Homewards, which is an organisation as well who are getting involved in this area, looking to see what exactly can we set by way of targets and actions to really make a difference to these young people coming out from both care and custody, and what can we do in advance of young people kind of coming up to that transition age of 18 to have them kind of move into accommodation that's going to suit their needs and have that support service around them. So we're in the early days of that, but we are developing specific actions, hopefully, which will also involve the private sector as well, because they need to be involved in this area of work. So that's where we are at the moment. So the direct engagement really hasn't happened, I suppose, with the Minister as such, but it's happening kind of on a cross-sectoral basis with all of the organisations to try and tackle this group who are very much in need.
Do you have concerns, but as part of this bill, that clause 8 won't be commenced by the Minister, though?
I suppose that wouldn't be something that I would want to comment on in terms of clause 8 specifically, because I don't feel that, I feel that on the ground we're actually linking up really well to have that accommodation piece enacted, and looking at the various routes and pathways. It's a very small number of young people under the age of 18 that we have in custody as well, so we should be able to solve this. We should be able to look at having the right kind of bail fostering or supported accommodation in place for those young people. But it does take us to kind of work together across the different sectors.
Well, it's important that there's cross-departmental work on this as well,
absolutely.
obviously with social services and the trust, but it's that legal protection though of it's not going to be commenced within the bill, and while it should be worked out, I was just wondering what the concerns would be, but look, that's brilliant. Thank you.
Thank you, Danny. Kira?
I just want to follow up just on that, which that is critically important that you're working around. You're saying it's a small cohort. It hasn't happened. It'd be useful for the committee to kind of get an update on that working group, because I know obviously the Department of Communities kind of secured funding for it and well aware of the Homeward project and the investment they've brought in. So I'd be really, really keen to see progress on that and where that's at. And will that include maybe capital as well? They have that wraparound support service. So that would be useful. I want to just focus a wee bit on biometrics, if that's okay, and maybe Gillian. Just regarding your views on the retention periods, just what's your thoughts on that, particularly with regards to children and young people? And then kind of secondly, what would be your views on the photographs that are not being included as part of the biometrics in the bill? And then just overall, do you generally feel that the retention periods and not having the photographs and all, etc., do you believe this could lead to the stigmatisation of children and young people?
I suppose we aren't directly involved in that area of work in the biometrics. Obviously, the consultation has taken place, and there's various views in relation to that and how to protect children in the midst of everything, and with those retention periods, whilst not labelling or stigmatising a child or having them being viewed as a criminal for any longer than really absolutely needs to be. The absence of photographs, it isn't something that we are directly involved in because of the very small number of children and young people that we are directly working with. But certainly at a high level, we're supportive of what's in the bill.
Just practically on the ground, you're supportive then of the current retention periods that are set for children and young people, and you're happy enough with regards to photographs not being considered then?
Yes.
No, that's fine.
In relation to the proposals that are being made, we're content with the proposals that are being made in the bill.
Yeah, well, it's one and the same, the proposal in the bill,
Yeah.
or from your practical experience,
Or
from Probation Board, the practical experience overall, that's your views, that you are content regarding the current retention periods, particularly for children and young people?
Again, because of the very small number of young people that we are working with, it isn't something that affects us directly, but overall we would be concerned about any impact of any labelling or stigmatising of children.
Thank you.
Connie?
Yeah, thank you, Chair. Thank you for coming in today and presenting to us. I wanted to pick up on something you sort of said at the end of your presentation there, around the minimum age of criminal responsibility. Now, this is something that quite a number of organisations have come to committee to say they wish this had been included in the bill, and I think I was really interested in to know your rationale for supporting 14, because we've had a range of views of 14 or 16 from different organisations, so I'd be interested to know the rationale for that. And as you were saying, you work with quite a small number of young people. Would that have a major impact on the work that you do as well?
Chair, I'll just give you some context and then pass to Gillian around the specifics on it. This was part of the board took this decision originally whenever the consultation was undertaken by the Minister. And in fairness, I think, I can't recall the specifics as to why they landed with 14. It was in relation to the capacity to fully understand the implications of their actions at that time. And probably from our perspective and working with people, it's seeing that investment in the prevention and early intervention piece to allow people not to enter the justice system to start with. And that has worked very well for the cohort of people that we work with, and also just that focus that for that cohort of very young children and young people, the focus on relationship-based and a trauma-informed approach, and also that therapeutic piece to address the issues to prevent them coming into the justice system, which is ultimately we as an organisation exist really to prevent people re-entering. They come to us after they're in the system, and usually it's for the supervision of the order. And the minimum age of criminal responsibility was largely that capacity to fully understand the consequences of their actions at such a young stage. Gillian, I'll maybe just pass to you around the specifics.
Yeah, in relation to the specifics and the impact on our work, between 14 and 16, it won't have any impact in relation to our direct work at this point in time, or even historically looking back again, because of the very small numbers. So a direct impact on our work, be that 14 or 16, there wouldn't be any. But again, the reason why 14 was, why we're supportive of 14 is in line with all of the research in relation to that and the child's ability. Obviously aware of other consultation responses saying that 16 should be the preferred age.
Just on that, would there be an impact then just raising it from 10 to 14? Is there much, do you do much work with a cohort in that age? And do you, I know some more jurisdictions such as down south have exemptions as well. Is that something that you could see would be workable, given that there's quite a difference in opinion in the Assembly here?
So in terms of our work directly with the 10 to 14-year-olds, that it doesn't happen, because all of that work would be undertaken by the Youth Justice Agency, who take the lead for the under 18s more generally. In terms of having a difference, I think in the types of offending and age of criminal responsibility, I think it's much clearer to have one age at 14 and flexibility in terms of the types of disposals or sentencing that there can be in respect of particular offending types, because I suppose it's all about the individualised approach to each child and looking to see what are the circumstances that have resulted in them committing the offence and what can be put into place to address that offending, support them to rehabilitate and reduce the opportunity of them creating more victims in society.
Well, thank you very much, appreciate it.
Thanks, Connie. Deirdre?
Yeah, no, thanks very much for that and just for your contributions. I just had a couple of queries around, I suppose the first one was around Clause 8 again, which I know Danny raised, and just the sufficient accommodation. And I suppose it was just because you did highlight the crisis and accommodation for adults, and we know that in terms of the housing crisis that we're in at the moment as well, and competing for accommodation between health, justice and the Department for Communities and the likes of mayors, in terms of the Home Office stuff around immigration. So I'm just wondering how confident you are that there is sufficient and appropriate accommodation in order to ensure that Clause 8 could be complied with. And I suppose the other balance to that as well, I mean, the broad thrust of the bill is to keep children and young people out of custody arrangements. So obviously finding accommodation within the community is essential. And it's just to see on your practical experience, do you see that there are better outcomes if children and young people remain within the community rather than actually, being in a custody environment? So just to kind of get your views on those two aspects, please.
Thank you, Chair. I'll maybe just ask Gillian to comment on the specifics, but just by way of it'll come as no surprise to you that we probably as an organisation, because we work in communities and are responsible for supervision of community orders, primarily for adults, we do believe that there are better outcomes whenever people are able to retain all of the links within the community, and also a recognition that, and it's an important part of our work, working alongside communities, because people come out of custody or else they come off a community order and they ultimately live within local communities, and it's really important that any interventions and the success of them tend to be community led and community driven, and that's really important to us in terms of our work. In terms of the actual specifics, I'm going to just pass to Gillian and Aidan if they have anything in terms of the practicalities of the work.
Specifically in, I suppose, the work that we do, we, again, as has been outlined, will work with agencies to ensure that people remain in the community because of everything that is outlined in relation to the impact, even a very short-term impact of losing accommodation in relation to family, employment and all of the factors that basically help somebody's desistance and them not reoffending again. So that would certainly be what our focus would be, and again we will work, whilst this is with adults, absolutely with hostels, to ensure that somebody remains in their local community and we can work with them and support them back into their local community. Specifically in relation to young people, Aidan, I'll pass to you on that.
Yeah, I mean, I suppose the cohort of young people who end up within the justice system, there's an overrepresentation, first of all, for young people from care backgrounds. So often they don't have that kind of supportive accommodation to fall back on rather than ending up in custody. So I know the Youth Justice Agency has done some good work in relation to bail support programmes to try and supplement a child remaining in the community through putting in those additional supports, and that has worked well. But we do know that there is a difficulty and a challenge around accommodation. I think in that report that I'd referenced around the review of jointly commissioned accommodation, at that stage in 2023, 18% of all the homeless presentations to the housing executive were aged 18 to 21. And that was almost 3,500 presentations. Now that would include young people and young adults coming out of custody, but it's also those young people kind of sofa surfing as well and moving around the system. So there is a need to actually look at what can we develop, what can we put in place to have young people remain within the community and to be supported, because as has been said, once you go into custody, your chances are reduced in terms of, getting back out of the criminal justice system again. So anything we can do to bolster that. But bail fostering, for example, for young people, again, would be options potentially that could be considered and developed.
There's a pilot underway for that, but it hasn't been used very much. So it's
no, I don't have the figures, but no, it doesn't appear to have been used.
there are only a couple of children potentially, and I think it's only one trust area, and I think they were looking at extending then the pilot to see.
Southern Trust in 2023. I'm not familiar with just the outworkings of it, but I know it was developed in response to that in 2023, which obviously does give cause for the concern around accommodation and how challenging it can be. I mean, if I could say something just in terms of what is coming across is just the desire of all of the agencies to try and work as together as much as possible, and I see it particularly around children and young people to address needs whenever they arise. But I do note the concern, around the legal footing around it. But what I see at a practitioner level across all the agencies I work with is a real desire to try and do the very best and get best outcomes, particularly for those very vulnerable, looked after children in particular. And there's models of working, particularly around Belfast, in terms of complex lives that enable us to do that. And that comes up time and time again, just the sort of efforts that are being made by agencies. But it goes back to that point that public services are under so much demand, and the lack of services and provision, particularly around accommodation and some of the other challenges that people who are coming into the justice system experience around mental health and addictions, is really becoming a challenge for all of us, and stretching those the community service and some of the the operational work that we then have to do to try and link in and cooperate with those agencies is becoming more complex even for ourselves.
Deirdre, you carry on with a few more there?
Yeah, it was just one more query. Sorry, thank you, Chair. And it was just on the biometric stuff, to go back to that in terms of, and we're struggling with all of this in terms of trying to get our heads around it. So I don't know if you've taken a consideration, but just when you said you're happy with what's contained within the bill, one of the emerging themes that are coming out from a human rights perspective and also from children and young people's rights is that issue of stigmatisation. So we know that the PSNI currently hold 180,000 photos, which at the moment under this bill is not included as biometrics. So I'm wondering whether you would view photos as biometric material. And the other issue then pertaining to children and young people in Scotland, biometrics is only retained in circumstances, particularly those under 18, in serious offences. And it's just to see whether you would have a view of those two issues.
If I can just, in fairness, in responding to the consultation, we have focused largely on the sort of part 2 in terms of children and young people. If the chair would be obliging, what I would like to do is maybe to go away and consider just some of the questions around biometrics and maybe write to the committee with supplementary evidence, just to give us time to consider it, unless Gillian wants to give anything by way of those specific questions.
No, I think that's going to be the most helpful way to do that, is supplementary response.
No, that's fair enough. Deirdre, you content with that, yeah?
Yeah, no, appreciate that. Thank you.
Is that you finished, or have you any more?
No, that's me done, sure. Sorry, thank you.
We always go at the end, ladies. A couple of things for me, just in the arena of the children's stuff in particular. Justin, you're indicating. You go first, and then I'll come in. Justin, go ahead.
Thank you, Chair. Thank you, ladies. Thank you, Amanda, Gillian, and Aidan. I guess a comment to start off. I think I might have touched this before. I'm moved by your obvious empathy, your emotional intelligence, your compassion for young people and adults who are caught up in justice system, often victims of their own circumstances, which is sad to see. And you mentioned some of those circumstances, but to what degree? Addiction obviously is one of those circumstances, right? An addiction where progranulin is a Class C drug which is so readily and cheaply available as part of a concoction of drugs which many people are using now, and it must be a total menace for the justice system having to deal with that reality. And for those young people and adults caught up with that addiction, it must be horrendous. To what degree are you supported? To what degree is the justice system supported, and along with their agencies, to prevent that cycle of reoffending and to prevent that as we mentioned a number of times, that stigmatisation of people involved and caught up with the justice system for whatever reason?
Thanks, Chair. I'll just maybe give you some context and then just pass to Gillian in relation to that. I mean, just to give you a sense, in terms of, we today are currently managing just over 4,000 people in the community. And whenever we last looked at the figures, over 75% of them have specific addiction or mental health issues related to their offending. So it is becoming a real challenge for us in terms of just some of the work. And you'll be familiar with, for example, the Substance Misuse Court, which is specifically set up to try and deal with the root causes of the offending behaviour, and to some extent is a deferred sentence, and has been really successful because it has that therapeutic intervention that's supporting the actual root causes, which tends to be the addiction issues which are causing the offending behaviour. And in many ways, with the types of numbers that we're finding, the complexity, that is becoming increasingly difficult. As an organisation, we took the decision this year, and it really is just in the very early stages, to employ a number of addiction-specific counsellors. And that's actually just to work alongside our own cohort of staff in terms of the probation officers and probation support officers and community service staff, really to respond to that growing need and growing demand that there is for specific work in relation to addiction. But I'll maybe just ask Gillian to comment specifically on some of the practical outworkings of it.
Certainly, as Amanda has outlined, we now have our own in-house counsellors, and we also have a lot of links with community providers in relation to substance misuse and alcohol as well. it is one of the key factors in relation to people's reoffending. So as people are presenting to us with addiction issues, sometimes it is their addiction issues that have brought them to the criminal justice system. Other times it's symptomatic of other issues in their lives. So it is certainly something that we have a strong focus on. All of our staff undertake alcohol and drug training as well, so that they know the issues that are presenting with them, with their service users. And certainly what we're seeing now is much more polysubstance misuse than what would have been the case previously. So staff are having to respond to what is presenting in front of them, which is becoming increasingly complex and at times leading to their service users presenting in a much more chaotic way as well. But through that support of our in-house counsellors and also other groups in the community, then we are able to support the individuals then to try to, I suppose, address the reasons for their addiction, which will then in turn help reduce the likelihood of them reoffending then as well.
Thank you, Gillian. Justin?
Huge challenge for you ladies, going to envy your tasks. Thank you very much, Chair. Thank you, ladies.
Okay, thank you, Justin. Ladies, thank you. First of all, I want to commend the Probation Board for the work that they do with offenders, but also, to ensure that wider society is kept safe and to give people a chance to rehabilitate and start again. And but in all of this, I think for me, in all these proposals, I think balance is the key. Whenever you're going to come back about biometrics, could I ask you, unless you've got a view on it now, I'm trying to find the balance between not stigmatising children and affording them an opportunity to rehabilitate and make something of their lives, versus the indicators that some of these behaviours represent. So we know, for example, that cruelty to animals is an indicator that things are going to continue on in adulthood. We know that cruelty to other children is an indicator of these kinds of things. So, to your mind, where's the balance? In affording them an opportunity not to be stigmatised, but also in terms of the public safety aspect. Retention of records and biometrics and so on.
Sure, I will answer some of that and then maybe pass to Gillian. We may well write to give further information if that's helpful to you, but maybe just by way of context to say, as an organisation, we absolutely understand the impact of offending behaviour on local communities and on individuals, and we see that every day through the work that we do alongside victims. And while we're working with offenders, I always want to make the case that actually we work really closely with victims as well, to make sure that they are supported throughout the journey that people have in relation to their rehabilitation and resettlement into the community, and never want to minimise that impact. And it is that piece that our staff constantly challenge themselves around in terms of striking that balance between care and control, which is so important in terms of the work. Just around the specific indicators in terms of just those early indicators, particularly children and young people, and maybe just pass to Gillian from your own practical experience as a practitioner.
It's a real challenge, and I think we will frequently say that the best indicator of somebody's future behaviour is their past behaviour, whilst also specifically in relation to children, taking into consideration that children will push boundaries and they will do things for a variety of reasons that they will never repeat. But again, taking your point here in relation to those really concerning behaviours, particularly the abusing animals, things like that, absolutely. So I think it is something that it's a very fine line, whilst also giving children the opportunity to be children and to move on from those behaviours as well. And I think it is something that we absolutely can consider as part of the further evidence that we provide.
Yes, I think if you would look at that aspect, just because I think we are trying to strike the balance here and not having these kids not have a future, but also there are wider aspects in terms of public safety that may be fairly severe as we move through this. So there is the issues there around, I suppose, the retention, but also the rehabilitation of offenders. Just on that note then, do you have any comments you want to make on the rehabilitation of offenders amendment? Have you had a chance to consider that?
Sure, we'll maybe just come back to you on
Come
that.
back to us on that too. That would be really helpful, actually, if you would. Thank you, because that'll probably have direct bearing, on some of your caseload. Let me see. A couple of things. Yes, we have heard from the profession that whenever children are in a care circumstance, more often than not, the police can be called in for kind of minor issues that they wouldn't be called in another setting, that impacts their bail conditions, leads to arrest and all of that. Do you think that the proposals in this bill alleviate some of that, or do you have any comment you want to make in that area?
Yeah, I think the provisions do assist in addressing those particular concerns, but I also think in parallel with that, there's work potentially that needs done with the staff, with the various kind of children's homes potentially that those children are coming from. I can absolutely appreciate why somebody will phone the police as a last resort because a child is not adhering to boundaries and is potentially at risk of harm to themselves or to somebody else within the unit. Restorative practices have been shown to be very effective in addressing some of those issues within the residential context, and I know that there are good examples of that previously. So again, that's an area potentially that could be strengthened alongside the provisions within the legislation. But I think given police officers discretion as well as to when a child has maybe breached their bail or committed another offence which is of that very lower minor level, is really helpful in terms of helping to alleviate. Children will make mistakes, children will act out, and they absolutely need to be held account, but they don't necessarily always need to be lifted and removed from a situation. I think there's more that collectively we all can do to address that.
Thank you for that. That's helpful. Just in relation to the same issue, if I could ask you to take a look at paragraph 11, paragraph 15 and 16 of your evidence paper to us. And I suppose, again, I'm back to this issue of balance. So we've got the breaches of bail issues, but we've also got, and the orders and so on, but then we've got that there shouldn't be bail conditions except in certain circumstances. And I think at times bail conditions have proven very helpful, including for parents, actually, to help them. And bail conditions should not be a replacement for responsible parenting. However, there are parents and families who struggle. So could I ask you, in light of kind of all of this that we're discussing, to kind of give further comment on paragraph 11 of your evidence and paragraphs 15 and 16 of your evidence, and the balance, I suppose, between conditions, no conditions, breaches of conditions, and also the impact on victims. There's been a lot of talk about supporting the community, and I think that that's right and it's fair. But the other side of it is there's also the victim is likely to be in the same community. So how do we balance this? Do you have views on this?
I think just in relation to that previous point that you were raising, which is linking to point 11, the fact now that within the bill there is that flexibility for police, not, as Aileen has said, not to arrest, that does provide some flexibility, whilst also for the more serious instances allowing that the child may need to be arrested and may need to be removed from the circumstances that they are in. And it is back to that point in relation to balance that you're saying about balancing the needs of victims, even if the person who has committed the offence is a child, and the child's needs. So certainly that clause 7 certainly aids that, and that's linked to our response at point 11. In relation to 15 and 16, the 4 years for a young person is of that sense is a long time for a young person. There are a significant proportion of individuals over 18 adults who aren't serving a sentence of 4 years, but absolutely accepting that for the more serious offences that then allows a longer period of time to work with the individual to address the reasons why the offences were committed. that relationship building and that work takes a long period of time, which is again why we would be supportive of the longer period of time for the more serious offences. Now I'm not sure if I've answered your question, or if there's more detail that you would like on that.
I suppose I'm just trying to understand, the presumption of 0 conditions seems to me to be quite an extreme position, on the basis that sometimes it's helpful. But by the same token, I don't want to see the police called and children regarded as being in breach for very minor issues that should not really be regarded as a breach. So I suppose what I'm looking for there is where is the balance, where's the right point. The thing that frightens me slightly, or it doesn't, I'm interested to understand whenever you say breaches will be reported at the next scheduled court hearing, and at that time the judge can reinforce the importance of adhering to conditions. If conditions have been applied, it's because it's considered the case is severe enough to merit conditions in accordance with these proposals. Therefore, if there is a breach and it's not brought forward until the next scheduled hearing, what's the sanction? Where is the onus to abide by the conditions? What's the sanction? If it's if nothing happens in the interim period, what do you envisage in that space?
For lower level breaches, I think for more serious breaches of bail, so again, as we've talked about, children in that care environment where police are more likely to be called, and there are more likely to be more frequent breaches of bail for maybe what would be considered as lower level incidents. That's where I think this does provide the flexibility for more serious breaches, and again, it would very much depend on the condition and the actual bail condition as well. If it is there to protect somebody, and it is being breached, and that person who is to be protected by the bail condition is feeling under threat or feeling unsafe, then in our estimation, they wouldn't be the ones that would wait for another month for the next court appearance, that they would be dealt with more quickly than that.
What are the circumstances in which a child would be better moved away from a specific community, maybe to get away from a peer group of friends who are, things? Are there circumstances there that you've taken into account, or?
I'm not sure that we've specifically, Chair, addressed those within the response, but yes, there may be situations where it would be best to have that child placed elsewhere for a period of time, as you say, to reduce their propensity to kind of link with that peer group or to reoffend against that particular victim. But that doesn't necessarily mean that they have to come into a custodial setting for that to happen. And I think it's that provision of, well, what else can be put into place elsewhere to have that child have a chance at succeeding and keeping those bail conditions. And I think the first thing to ensure is that child understands at the outset what these bail conditions mean, whether it's police bail or whether it's court bail, because very often in a court it kind of goes over their heads and they don't fully understand. And again, the Youth Justice Agency have been really helpful in terms of that direct work with young people, helping them to understand what the conditions actually mean and what the implications, more importantly, are if they breach that bail. And then sometimes they can bring additional resources to bear as well to support that young person to adhere to those conditions within the community. So, again, it's back to the basics. If they understand it and they're willfully going out to breach conditions of their bail, then yes, absolutely, perhaps they need to be brought back and held, to account before the court as well, more quickly than the next appearance.
That's what I'm trying to figure out is, this proposal is that there are very limited circumstances in which there would be conditions at all. And I'm not sure I don't think there should be excessive conditions, but I think trying to rule them out isn't always the best thing either. I had one last point and I can't remember what it was. I'll come to it. Ciara, you wanted in again?
No, it's probably just following on from yourself, and it's just in relation to paragraph 6. And around the terms of threat to public order. And obviously there's likely only to apply to a very small number of children. I suppose it doesn't matter how many small number of children, that's a child. And the test for refusal of bail will require the 2 conditions to be met. and that the offence is likely to result in a custodial sentence and they are at risk of offence. It's just, have you any concerns around it, or just what's your thoughts?
Comment
on it,
just
or
very generally first, I suppose in a sense there's always the issue around and we find it with the Aspire programme in terms of child exploitation and coercion, and one of the concerns probably reading some of this is that children are being punished for the actions of others and the potential for that, so that a place of safety being that they go back to the community, being a concern around how others might behave towards them. I'm going to lean into just Gillian or Steve or Gillian or Aidan just to comment on the sort of specifics of it.
I suppose, we need to be clear, is it the child that's presenting the threat within the community, or is the child at risk themselves within the community? And, it wouldn't be right, because the child is under threat from within the community, for them to be remanded into custody. I think we need to look at alternatives to keep them safe. But where the child is at risk of further serious harm against a victim or somebody else within the community, that's absolutely right that they need to be put within a place where they can be managed and supported, and the public can be protected in the future. I don't know whether I've kind of answered that.
No, I think that it's,
yeah.
I suppose it's the
Just
further
to tease it out.
conversations, but it's
Mhm.
definitely useful to
Yeah.
just tease that out, just in relation to around the whole public order thing versus the child and the victim as well, obviously. No, thank you for that. Yeah.
Nice, Ciara. And I actually think that's not just a child issue. That's if you're entitled to bail, you're entitled to bail, and it's not about the mob saying you can't have bail. Yes, my last point was this. We've received evidence from other groups that have indicated there should be some degree of flexibility around where a child is in the youth justice centre and is about to turn 18, coming towards the end of their sentence, rather than that child being moved to Hyde Bank, for example. They should be allowed to stay there just to see out their sentence for a short period. Do you have any views on that?
Sure, just on a general point around the working relationship that we have with Youth Justice Agency, and then this is an issue that comes up quite a lot for us as an organisation. We work really closely with Youth Justice Agency in trying to do the best for young people, and obviously there is the opportunity to streamline this. We do have a memorandum of understanding in relation to the operation of this, but actually those good working relationships exist to do the very best for young people, but also to maintain public safety. Erin is the link with Youth Justice Agency around those transitional arrangements, and I'll get her just to comment on them and how they work.
Yeah, I suppose generally for a child who's approaching the age of 18 and has a period of custody to remain after that, we'd need to consider kind of what length of time. If it's a further kind of 8 or 9 months, absolutely they need to move to Hyde Bank Wood, because they will be managed as an adult when they come out for supervision within the community. However, we know that they're often very vulnerable children who turn 18 whilst they're in Woodlands, and maybe their period of custodial supervision is coming to an end within a couple of months, maybe up to a period of 6 months potentially. Would it not make sense for those young people potentially to remain within Woodlands? However, we need, again, it's all about balance. We absolutely have come forward and we're saying very clearly no over 18 should be held in Woodlands. It's whether we can have that flexibility to make exceptions based on vulnerability, based on the length of custody to go in terms of that. So where it's possible, the relationships will have been made within Woodlands. Often they've done very positive work in terms of their offence focused or psychology or whatever the input has been. And to break that then by a move to Hyde Bank can be very unsettling for some young adults.
I'll just follow up on that with you, please, Erin. Just appreciate, it may not be a question for you, but just from your experience, as I'm exploring this issue in my mind, have there been circumstances, what's the extent to which those who are 18 who move to Hyde Bank have been kind of destabilised by the move?
I think both Youth Justice Agency and Northern Ireland Prison Service work extremely well together to manage those transitions and support the young person taking the steps from Woodlands to Hydebank. So, for example, NIP staff would come down, they would talk to the young person about the differences in regime, the fact that they're prison officers and not social workers or community youth workers working with them. You know, so they manage that very well with young people in my experience. So we haven't had those difficulties of young people kind of being knocked off balance almost by a change in their environment. And again, we know that Hydebank Wood has a very supportive approach to young people who are making that transition from Woodlands. And again, we're talking about very small numbers again who fortunately kind of have to move on from the children's facility to the adult prison.
Well, that's really helpful to know. Thank you very much indeed. Does anybody have anything further? No, all good. On that basis, could I thank the three of you for your time and your evidence, both verbally and in writing. If you're going to follow up then with us on biometrics, there's just a couple other bits and pieces there. Could I ask you to, rehabilitation of offenders, maybe you'd look at the restorative justice amendments too, and if there's anything else there that you deem relevant, we'd love to hear from you. Okay. So thank you very much indeed.
Thank you very much.
Thank you for taking the time. It's good to see you again, Amanda. All the very best. Thank you. Oh, we're good, okay. Justin, just before we move on to Niakro, could I flag up that if you leave, or indeed if any members in the room leave, we're in court. So we could hear evidence, but we couldn't take any decisions, and we've got decisions to make later on in the meeting. So if everybody could just bear that in mind. Members, agenda item 5 is further evidence on the Justice Bill, this time from Niakro, and I'd ask you to turn to pages 31 to 68 of your pack. We have Fiona Green, who is the Chief Executive, Rachel Long, who's the Director of Operations, and Andrea Moreland, who is the Senior Practitioner for Disclosure at Niakro, and they're going to be in attendance to give us evidence. Just getting set up. Hello. It's nice to see you all. Thank you very much for joining us today. You're very welcome. Ladies, I've just introduced you before you came into the room, so thank you for taking the time. We've received your written paper, which was very helpful. The way this usually works is I will hand over to you for some opening remarks if there's anything additional that you want to point out to us, and then we'll open to members for questions. Previously we've done it kind of thematically, but your evidence kind of has a natural flow to it, so I haven't forced members to abide by my housekeeping rules. So we'll just kind of go old school, and as members indicate, then we'll take questions. Are you content with that?
Yeah, thank you, Chair.
That's lovely. Thank you very much. I'll hand over to you.
I'll start off then. Thank you, Chair, and to the committee for this opportunity to speak to you today on the draft Justice Bill, which is in front of you, and specifically as relates to the work of Niakro. You will have already have had a written submission, which includes general information on Niakro and our services, but very briefly, we are a voluntary organisation working since 1971 to reduce crime and its impact on people and communities. We are guided by a vision of a society where the rights and needs of all people are equally respected and protected. Niakro has a diverse range of services, and we operate across all constituencies in Northern Ireland. These services include early intervention programmes, mentoring support, employability services, finance and debt advice, and family support programmes. We are creating meaningful change for over 7,000 individuals annually and facilitate over 30,000 prison visits across the prison sites each year. We work closely with the Northern Ireland Prison Service and the Probation Board, both at an operational and strategic level, to deliver a range of trauma-informed programmes and services designed and delivered together with aims to reduce reoffending, support rehabilitation, and improve the effectiveness of the criminal justice system. Our collaborative work focuses on strengthening family ties, maximising opportunities for training and employment, so for example through our UK Share Prosperity Fund employability programme, and supporting stability with housing, health and finances, for example through our Aspire and Transitions probation funded programmes. Niakro are also commissioned by and work closely with the Public Health Agency, SPPG and several of the health and social care trusts, providing early intervention and support services to families and children in need across Northern Ireland to support our strategic goal of reducing the numbers of young people entering the criminal justice system. It is important to us today at this session and through our written submission that the committee get a clear sense of the lived experience of the people we are here to support and who are and will be affected by the success of this legislation. So moving to the bill, we note that as it has been introduced and with the addition of the proposed amendments, this represents a complex and technical piece of legislation. We are cognizant of previous committee hearings on the matter and note that the committee are taking a comprehensive and detailed approach to understanding and discussing the matters at hand. So you can make best decisions and recommendations on the merits of the bill. So for example, on biometrics. So given our expertise and our own policy priority areas, and to best assist you today, our evidence will primarily focus on the proposed amendments concerning the Rehabilitation of Offenders Order 1978, as well as our own proposal for the addition of another amendment, that is to raise the minimum age of criminal responsibility, MACR, noting that both matters have been subject already to DOJ public consultations in 2021 and 23 respectively. For the record, we have also provided some more high-level feedback on other proposed amendments and commentary on the 4 parts of the bill as introduced, as all areas of this bill have the potential to impact on existing and future service users of Niakro, and we are of course happy to discuss and take questions on these if appropriate. Niakro regard this bill as a vital legislative tool that must align with the Northern Ireland Executive's commitment to creating safe community, as outlined in PFG. As such, it presents an opportunity to establish essential legal mechanisms to help support the delivery of the proposed cross-departmental strategy to reduce offending and reoffending and to bring about improved effectiveness and less delay in the existing criminal justice system. Additionally, this legislation should facilitate the implementation of the Strategic Framework for Youth Justice and the full implementation of the Youth Justice Review 2011 and ensure that the youth justice system delivers improved outcomes for children, families, victims and communities impacted by crime. You will see from our submission at the section which specifically speaks to the Rehabilitation of Offenders Order that we have focused on a number of themes, including reflection on the original intent of the 78 Order, and we have provided examples of the lived experience of people held by Andrea here, our disclosure expert, and her colleagues in our disclosure service. We hope that these live cases detail the ongoing impact of having a criminal record and how it affects someone's life, employment, travel, insurance, and gaining access to education as well. The original intent and stated aim of the legislation, first enacted in England and Wales in 1974 and then transposed to Northern Ireland in the existing 78 Order, was to restore the offender to a position in society to that of one that was no less favourable to someone who had not offended. The purpose was to enable people who did not commit further crime to move on and have a second chance and secure employment. Having a job is the biggest single factor to prevent reoffending. It is important that we understand that employment acts as a protective measure in itself and that having people in work protects society. The legislation was never intended to act as a public protection tool, but as we have stated, as a tool to achieve full rehabilitation. However, it appears over time to be viewed as such, which has complicated the public discourse on unspent convictions. As we have detailed on our paper, there are a range of public protection measures in place that should reassure the public and your constituents that no one will be placed at risk as a result of this legislative progress. In terms of our overall response to the proposed amendment to the rehabilitation order, Niakro have been campaigning for decades to have the order updated to bring forth a more fair and proportionate spent conviction system to this jurisdiction. So we are pleased to see the potential changes now in draft form, especially as we move away from the current situation whereby any custodial sentence over 30 months can never be spent. We applaud the DOJ's efforts to reform the current legislation, as for many people, time has been served, sentences are completed, but the punishment continues. People are branded criminals for life despite life progress made, and they are never allowed to forget and therefore never allowed to fully move on from past actions. While we broadly welcome the reform, we feel that there's a potential missed opportunity to align with the legislative advancements in England and Wales, which have been in operation since October 23. At the time of the consultation in 21, we viewed the proposals as more forward-thinking, but believe now it may lag behind England and Wales again, who have amended their 1974 Act, to ensure that custodial sentences exceeding 4 years become spent after the sentence duration plus 7 years, except, of course, for certain excluded offences, which was introduced in Schedule 18 of the Sentencing Act, which remain exempt from rehabilitation. Excluded offences include murder, manslaughter, terrorist offences, many sexual offences including rape and sexual assault, and some violent offences including GBH and ABH. Niakro would take this opportunity to call on the committee to revise the legislation to ensure alignment with England and Wales, and that there is no bright line, currently 10 years proposed. And our view is that this will remove unnecessary barriers to rehabilitation. You'll also see from our case studies that the disparity between the two regimes present people living in Northern Ireland with practical challenges of knowing when their convictions have been spent, and they are no longer required to disclose. So that is why we have designed our own calculator and website for Northern Ireland, and have a helpline and disclosure service to support individuals, agencies and businesses around this very technical matter. If this legislation goes forward, as it has the potential to positively impact tens of thousands of people and make a contribution to savings in the public purse in terms of reoffending costs, which in 23 was £374 million. We believe that it will also support economically inactive people to gain training, skills and employment. It will support businesses to safely and fairly recruit. In our research conducted with the University of Ulster a number of years ago, most employers said they were willing to employ people with a criminal record, but they would need help and advice to do so safely. It will help people and families enjoy the benefits of living in a civic society by fairer access to insurance, travel, financial services and education. And we believe it will also help anyone who was under 18 at the time of conviction to move forward sooner. So at the other end of the spectrum, as we assist people out of and away from the criminal justice system, we also need to focus on preventing and diverting people into the system, especially children, and that is why we want to see MACRA raised. We acknowledge that there is a lack of cross-party support for this, or a consistent view on what the age should be. We welcome the opportunity for this committee to meet with young people who have experience of the criminal justice system to discuss in conjunction with the work that you're doing with Include Youth. And I think that will be an important opportunity for the committee to discuss the matter with young people themselves. But as the committee are very aware, and given the previous input on this bill from colleagues in Bernardo's, Boswa, Nicky and the Children's Law Centre, the age of criminal responsibility in Northern Ireland is currently 10 years old, which, put simply, is too young. Way back in 2011, the Youth Justice Review found that the age of criminal responsibility here was not internationally acceptable, and that we believe the time has come for action, not least to reflect current practice and concerted efforts by the agencies to divert as many children and young people away from the formal system. The UNCRC recommend a MACRA of at least 16, which we support, and believe that this legislature, Northern Ireland, have a real opportunity to lead ahead in an evidence-based way to support all children and our response to them when things go wrong and harm is caused by them. Raising the MACRA in Northern Ireland will remove significant numbers of children entering the criminal justice system, preventing them from having a criminal record for the rest of their lives, which leaves them with future barriers to employment, education, insurance and travel, as per our earlier comments on the spent conviction system. as well as increasing their risk of further involvement of the criminal justice system. Raising the MACR will mean a welfare and trauma-informed approach instead of purely punitive one. Instead of a purely punitive one, and can be taken to address complex needs and to reduce risk. We are not saying that challenging behaviour should not be addressed, not at all. It is a question of how we address it. Too many children and young people are being criminalised, many of them care experience, and you understand that. So as we all, the adults, grapple with health and social care reform, the impact of lack of progress in this regard should not be borne by our children. Responses are also required outside of the criminal justice system to support the complex needs of children with alternatives to the criminal justice system, and this will require cross-departmental planning and implementation. Invest to Save measures like early intervention programmes and collaboration between all sectors, including the voluntary and community sector, will be needed. There should be no exceptions to the MACR in line with UNCRC recommendations on best practice. We recognise the need to hear and understand the views of victims within this debate and also of local communities. We note Victim Support Northern Ireland's recent blog, it was in February 25 of this year, on the QPOL website, in which these are lending support to the MACR being raised. I asked this committee to consider, why are our children more criminally culpable than other children in the rest of Europe? So we would encourage the introduction of an amendment on MACR as part of this Justice Bill. We believe it is long overdue and will be a missed opportunity to put children's rights at the centre of our legal and care systems. We have outlined 13 recommendations in our paper, in our submission, covering the issues and the range of themes within the bill and the proposed amendments. But in conclusion, the Niakro key asks are this: reform the Rehabilitation of Offenders order, but to revise the legislation to align with England and Wales, removing the bright line 10-year proposed time limit when no conviction can be spent. And 2, for the committee to consider introducing an amendment to raise MACR from 10 to 16 years of age. We're looking forward to your questions, and we'll do our very best to answer them together as a team. Thank you.
Well, thanks very much, that was really helpful, and as was your paper. The issue about MACR, I suppose, in terms of a committee amendment, is that the executive couldn't agree.
Yes.
And bear in mind, this committee is mostly made up of executive parties, then the chance of agreement in here is probably slim as well, but we'll not rule anything out at this point. Danny, you want to come in? Connie, was that you indicating as well?
No,
not yet. Danny, go ahead.
Thank you. I'll start with the raising the age of criminal responsibility. We've heard different evidence where some will say 14, others are saying 16. Can you just suppose give your view on why 16 and not 14?
Our view is just in line with the UNCRC, so international recommendations and best practice, and taking on board, I suppose, the comments made in the 2011 Youth Justice Review in 2011. We've also, a number of years ago in 21, I think it was, with FOIPIC, Include Youth and the Children's Law Centre, alongside the Centre for Children's Rights at Queen's University, produced this paper called Tracing the Review, which we're happy to share with supplementary information after this session, which sets out our full rationale, I suppose, for asking for 16 with no exceptions. And it is simply that we believe that Northern Ireland has an opportunity to lead out on this. 10 is too young, clearly, and we would suggest that 16 is appropriate, given other areas and, in relation to the age of 16. 16-year-olds can't vote. They're not allowed to get married with another adult or an adult's permission. So there is I suppose it is fundamental to the debate of what is a child.
Yeah, I'd love to see them have a vote at 16 as well. As part of your paper, they asked the department returns to the recommendations of the 2011 Youth Justice Review in relation to criminal records. Could you elaborate on that just a wee bit for me? Why that is, and why you'd like to see that?
That was in relation to the...
In relation to filtering?
Sorry.
Yeah, sorry.
Yeah, do you want to take that one?
So I suppose in relation to if it's in relation to filtering, you mean of their records.
Yeah.
So I know Nikki and the Children's Law Centre and so on, have talked about the Wipe the Slate Clean ask. for children and young people, and it does, I suppose, come back to Niakro, I suppose, for us as well. And if you look at the numbers of children and young people who are coming into the criminal justice system, and the types of offences, and mostly it's first-time offences that people are, have whenever they come in to the system. So for filtering, we would ask that if you look at Canada, suppose you look at Scotland and you look at other jurisdictions as well, it's really important that unless it is a serious offence, if it's a first time and minor offence, in those other jurisdictions, it is not held on the young person's record, and it doesn't appear. I think unless certainly, for an enhanced check, depending on the role you're going for, of course we would want information to come through in order to safeguard and support, depending on the role that you're applying for. But if we take it back to, these are offences that children have maybe committed, low and minor offences in their early youth. And I suppose all of this links back to the rehabilitation piece as well, and people being able to move on and in their lives. So for us, very clearly, we would ask that if it is a low and first time offence, that consideration would be given that would absolutely not show and not be held on a young person's record then past 18.
Yeah. Thank you. And just one last question, it's to do with live links, and just any of your concerns you'd have around children and young people and the use of live links and even vulnerable people.
That was one of the issues that we believe that we need to take some more time out to consider. We are aware, obviously, of the effectiveness of live links as a means to access to justice, particularly for vulnerable and intimidated witnesses, and particularly young people, and through the witness service with NSPCC and VSNI. And we are, mindful of the fact that, we as an organisation are also campaigning for reduction in delays in the criminal justice system. So we support any means to do that. However, in terms of live links for children, regarding as what is proposed in the bill, we wanted to take some time out to talk to some of our children and some of our young people to get their views so that we can properly give a more of an evidence-based, robust approach to it. So, as I said at the beginning, we focus very much on the rehabilitation of offenders and the macro aspects of the bill, and also filtering as well, because those are the things that we are dealing with on a daily basis. Every matter within the bill is important in of its own self. So we recognise the practical solution that would give place in relation to the matters that are contained in the bill, as I said. But it is about balancing and proportionality. All of these things are, and understanding what support systems are put in and around young people and their guardians, and the people around it are supporting them during investigations and arrest. So,
thank you, Chair. Thank you.
Anybody else? Ciara?
Yeah, just come in on biometrics. Is that okay? Just in relation to obviously the 75-50-25 data retention model, particularly its application to children. Just in your opinion, would the bill, or does the bill, differentiate appropriately enough between children and adults? And then just secondly, you suggested in your presentation that the bill's approach to biometric data retention doesn't sufficiently align with the principles of the UN Convention on the Rights of the Child. So it's just your thoughts on that then. How do you think maybe the bill could be amended to ensure these rights are protected?
Okay, thanks, Ciara. So this is something we have given some thought to. We very much welcome the reform in relation to I suppose the indefinite period, not taking place any longer, and an end to that, so that it is more in line with children's rights. I suppose we have looked at it through the lens of the retention, if you like, again going back to the bill around the rehabilitation of offenders and when convictions can become spent, if you like. So we have looked at it in that lens, and when you look at the proposal where biometric data would be retained for diversionary disposals, our view would be that it absolutely shouldn't be. A diversionary disposal is a diversionary disposal. It's an out-of-court disposal, and in order to divert and not bring people into the system. So we would ask that diversionary would not be held. Moving on then to biometric data for non-custodial sentences, I suppose, if I'm reading the bill correctly, the proposal is that that would be retained for 5 years. And I suppose we don't feel that that's either necessary or proportionate. And if you look at the proposed amendments around the rehabilitation regime being updated now moving forward, if you take that very example of, you know, a non-custodial, say, a community sentence for a child, you know, that would be spent on completion of the order. So if their conviction is going to be spent on completion of the order, what would be the need for their biometric data to be held on a police computer system for 5 years after the length of the sentence? It doesn't align with what we're proposing in relation to that child's, you know, conviction being spent. So for us, that was just to give it that context, and so that it aligns with rehabilitation legislation and what's being proposed. Yeah, so hopefully that helps.
Oh, it definitely does. And then just on, and I know we've raised it on numerous occasions with other organisations as well, it's just the potential or the ongoing stigma that can come or arise from it. Just from your own experience on that, could you maybe just throw some light on just currently ones with having that convictions and having that hanging over them with their data being held, etc.?
Yeah, very much so. I mean, I can talk even from my personal experience. I'm a foster carer as well, and provide respite. And I mean, just very recently, in the last 6 months, have looked after a young girl who's 17. You know, and as we talked about, over 30% of children and young people in the Juvenile Justice Centre, or even higher than that, come into the attention of the police, are from, care experienced young people. And one of the young people, we were just talking about this, that I have looked after, so she went missing for a period of time from her children's residential home. Who were looking after her, and rightly so, people were concerned for her whereabouts, and the police put a photograph out in order to ask for support if anybody was able to identify her. And very much so after she returned, and I was looking after after this, and one of the first questions she asked me off her own bat was, will the police hold my photograph, and how long will that photograph of mine sit on the police system for? What information have they got about me? So young people really do care, about this, and they do take it seriously. Every young person is different and comes with different backgrounds and different family experiences and has different resilience levels, but they do care. So again, I think I would welcome when you hopefully do get an opportunity to meet with some of the young people that we support and other people support, that's a question that they would be interested in engaging with you about.
No, thank you. That was great. And I'm sure that young girl was very fortunate to have you. And what I would say, you also raised that point of them not being aware at all.
No, and
who
it's
has their
an
data,
issue.
where it is and where it goes either, so that front end of consent as well.
And for children and adults, even
aspect
through
of
our
it.
disclosure helpline as well, those are the types of questions we would be asked through the work that we do. We provide lots of advice through a disclosure helpline to people, and they will ask us information about how long, where does this sit, who will see my information, how long for. So it is important that people are educated and know.
Well, thank you.
Okay, Karen. Connie?
Yeah, thank you. Thanks for coming in today and for your evidence. I really appreciate it. I wanted to pick up on one of the points you'd included, I think it was number 9, that you'd asked for the inclusion of an additional clause at the outset of the bill, explicitly establishing a child's best interest as a guiding principle. And I just kind of wanted to hear your thoughts on that, and if you have concerns if it's not included, and if you think current legislation around child welfare and the best interest isn't sufficient.
We were in our own preparation for this committee meeting really struck by the evidence that was given by others, the Human Rights Commission and in particular the Children's Law Centre, around this. It would strike me that it wouldn't be controversial to include wording and verbiage around children's rights being at the centre of any legislation really that pertains to them. So that was my view on it. Really.
If you don't want to come in, so there were a few things for us just that came up, particularly in relation to bail for children and young people, even custodial arrangements for children and young people. So some of it is around bringing into legislation custom and practice that's already happening, but I suppose other bits particularly that we were concerned about or that we would like you to explore further, obviously are in relation to how the assessment of a child's maturity in a in a police custody situation, you know, how are police going to assess the child's needs, their capacity to understand, you know, the conditions of the bail that are being attached to them. We also had, you know, questions, as have others who have provided evidence previously, around, you know, the child's community ties as well. And so all of that in relation to the child's best interest. So we think that that's really important, that is very clear throughout all of this, that the child's best interest must be paramount in relation to all of that.
No, thanks. I just really wanted to hear more of your thoughts, because you're not the first organisation who's raised this with us, so I appreciate it. Thank you.
Thank you. Do either of you guys online have any questions? They're not indicating, so I have a few things, if that's all right, if I can just work through with you, because this is kind of the first time that we've really kind of focused in on the rehabilitation of offenders, and so this is us kind of starting to chew the issues on this one. You'd raised some concerns about the independent review mechanism, beyond the fact that that potentially couldn't be done in this mandate. Do you have any other concerns around that?
Well, other than that, it won't be within this mandate, so we feel that it's an important mechanism. That, I mean, do you want to say anything about that, Andrea, just around about that?
So essentially, the gist of your concern is that there'd be provision for it, but it's not going to be implemented until further down the line, which means that all of these people still who have a conviction of over 10 years have no means to actually get it looked at. And we've seen some of your case studies, and that has been I can see how that's an issue. Are there any you'd kind of indicated that it'd be your preference that pretty much more well, that's what I'm seeking to know, that pretty much everything could be spent after 10 years. Is this just for children, or does it include adults? And are there any convictions which you think should remain and be disclosed?
Yeah, for sure. So do you want to take that?
So we would be wanting the legislation to change around rehabilitation for adults as well as children, obviously. So in regards to convictions that shouldn't become spent, we do believe that everybody should be given an opportunity to rehabilitate. People may have committed an offence once, never committed another offence, and that's been hanging over them since they've committed that offence. We would want these people to be treated fairly, because they are not able to maybe access employment, education, maybe they can't get insurance. There's all kinds of different issues that having an unspent conviction can raise. But we understand concerns of the public, the Assembly, about safety of certain people whose convictions could become spent under the new legislation. But what we want to put forward about that is that there are public protection orders in place as well for those people. So you've got things like sexual offences prevention orders for serious sexual offenders. You've got VOPOs, which are for violent offenders. You've got barred lists, public protection arrangements, things like that. So even if a conviction does become spent, some of those supervisions last past the spending period, like the sex offenders registration, for instance. I don't know if we have a particular stance on any convictions that we don't think should become spent.
You know, we consult and so there's a specified offences consultation out at the moment, and that's currently out, and we really welcome that, you know, that there is consultation on that. So when there is something to be added to the exemptions list, you know, we do take that into consideration, you know, and do put forward a view on that. So I suppose we are in agreement with the main number of categories that are contained in that at the moment. So with some of our practice experience, though, if you were to ask around some, you know, that maybe could be considered where they would fall out. So if we look at England, I suppose our call and our ask in Niakro is that we would be in line with England and their rehabilitation periods. So as you say, anything over 10 years there can become spent. And we speak to our English counterparts, and we do get phone calls from people who are, you know, conflicted between the two, or they're maybe moving from Northern Ireland and trying to understand what that means. And what they tell us, I mean, they've had this in place from 2023, and how we look at it is, for example, if you serve a long sentence, if you've been sentenced to something over 10 years, it's for, you know, quite a violent or serious offence. So say, for example, you've served a sentence of 15 years, you know, under the proposed amendments, and what we would like to see is it would be your length of sentence. So you're talking 15 years plus another buffer period of 7 years on top of the 15 years that you've already served. That's a pretty long time in order to demonstrate, you know, that you haven't offended either, because most sentences now are like a determined custodial, where you'll serve, you know, part of your sentence in custody, but most people then serve a part of that in the community. So they've, you know, hopefully not reoffended during their period in the community, and then they've had a further 7-year period where they haven't offended either. So what we would like to see...
So it's not even taken from the point at which they're in custody, it's the end of the sentence.
It's the end of your sentence plus a further 7 years.
Yeah.
So you can imagine, no matter the length of the sentence, there's a further 7-year period. And what I suppose is really important to us, that if you look at the evidence tells us that, you know, for somebody who hasn't, you know, hasn't reoffended after 7 years, that the risk of them reoffending is the same risk as you or I, or a member of the public who has never offended. So that the risk of offending becomes the same. So that's why the 7-year period, I presume, has been set. But for us, it is really important that we do think there should be that independent review mechanism where, you know, it should be taken into consideration. So there should be exceptions, absolutely there should be exceptions, and we're quite content with the majority of the exceptions. We do get the odd case through our helpline, for example, and we've highlighted one of them. So maybe, for example, around, you know, drugs is a specified offence, so possession of drugs. We've had children and young people who maybe in their youth have been in possession of cannabis or of even a Class A drug of a small quantity. I mean, that's something that is going to be specified and will always be disclosable on an enhanced standard and an enhanced check. So I suppose we would ask that in some instances, for those people who have moved on, haven't reoffended, it's been one offence, that those could be, you know, reviewed by an independent reviewer. So I think it, you know, for us, our ask would be that there would be that independent flexibility around those situations.
So if I can, I just want to make sure that I've got this right.
Yeah.
Ideally for you, convictions would be spent after 10 years. In circumstances where that's not going to happen, you're content with an independent reviewer. But your concern with that is that it's not going to happen in this mandate. Is that a rough summary of where we are? With
Ideally, we would like it that there's no bright line, no 10 years, so that there's no upper limit. So all offences can become spent. So it would be the length of their sentence plus 7 years. Whereas at the moment, what's being proposed is maximum 10 years. Yeah.
I think that there are some issues there. I think there are issues contained in your paper that we would want to send on to the department and say, what are your views on that? And this is what I think one of the issues that I would certainly like to do that with the committee's agreement is around, okay, well, what consideration did they give to England and Wales and what's going on there, and why did they choose to go a different route?
I think, as I said at the beginning, when the department consulted on the order way back in the previous mandate, we had viewed it when we were putting our submission in that it was actually more reachy and progressive, but in the meantime England and Wales have moved forward with their legislative progress in it, so that bright line has been removed from them. So we would like to see it, because there are, as I said, it's the fairness thing, it's about proportionality, but there are practical issues about the two systems running alongside each other. And I know that we drew attention to a case study within that when someone was applying for financial service insurance online, which is an English-based, I think, insurance company, who are attached to the unlock calculator. So we've had to develop a Northern Ireland calculator because of the regulations are obviously quite different. And that was also one of the reasons why we set the table out for the committee, because it took us a wee while as well to, I suppose, say, well, this is where we are, this is what's proposed, and then we could compare it to England and Wales in terms of that, because Andrea is, and her team are constantly coming across this, that people think that, well, I don't have to disclose because they go online and they read it and they think it's the same thing. And I think there is a lack of public awareness just around unspent convictions anyway, because there's tens of thousands of people with, minor records, but they're criminal records, so most disposals are fine. So at the moment, it's 5 years before that's spent, so that can really, really impact on people. So that's why we've set it out in that way, just to give a comparative and also what our position is on each of those bits, really. Yeah, of course.
Just maybe to add to that, I know that the Minister did
Yeah.
set out to say that I think the reason that they took the position that they did take was because they felt that for people who would be impacted over the 10-year mark, you're talking about 20 people maybe a year in Northern Ireland. So they thought that that would be, I suppose, a reasonable number in order that, you know, an independent reviewer,
Yeah.
you know, would be able to deal with those rather than, you know, having that open to 10 years and above. So that's what was set out as to the reasoning for the 10-year.
Well, it'll be interesting to see. I mean, obviously that was done, what, many years ago, 5?
Yeah.
So it'll be interesting to see if there's been any discussion or thought in the interim period before they produced all this to see, you know, where we are. I think we should maybe, you know, query a couple of things. Excuse me a second. Thank you. Can I ask you, just around the restorative justice issue, you've highlighted there's some inconsistencies in restorative justice and some issues around access to restorative justice. Could I ask you to elaborate on that a bit for us, please?
Sorry, Chair, can you just...
Yes, let me just establish where we are.
Yeah. Yes, just... Oh, I suppose that's...
Yes, paragraph 4.
Yeah, yes. I suppose it's just we co-host the Restorative Practices Forum, and I myself personally sit on the DOJ steering group for the Adult Restorative Justice Strategy. So we are very aware of the work that's ongoing in terms of the development of the accreditation and all of the governance arrangements around adult restorative justice, and both in terms and also the work being done by criminal justice agencies in terms of how adult cases come forward in terms of referrals. I suppose at the moment there are numbers of restorative justice organisations and communities in Northern Ireland, but because of the funding, it's inconsistent, really. And also from a victim's point of view, we would hope that victims can also access more freely restorative justice interventions. Our view, we've always been supportive of restorative justice, and we recognise that there are issues around the funding and the resourcing, particularly at the moment, in terms of what might be a really good alternative to more traditional criminal justice solutions. And particularly for victims, it can be very powerful intervention and actually more satisfactory than the existing criminal justice system in terms of justice served. But it's not just as an alternative to the criminal justice system, it can be done in addition to provide hopefully more satisfaction and more repairing of harm between the person that's caused the harm and the person that's been harmed. So we are very supportive of those initiatives and would want to see a consistent, I suppose, approach to the resourcing of that, both in terms of the volunteering community sector being supported, the organisations that have been working really solidly over the last number of decades in Northern Ireland, for that work, and that big body of work to be recognised and built upon, as well as taking forward the Adult Restorative Justice Strategy in the DOJ, and we commend them for the work that they're currently doing to bring that forward, albeit that it's in a very challenging fiscal situation.
I suppose just to add to that in relation to, we have a programme called the Aspire Programme in partnership with Probation, and I suppose that's one of the only programmes for us organisationally that we are able to provide a restorative justice element to the work that we do, and that programme's funded through the EPOC strand, and we know that that's due to come to an end, with their winding down that programme. So I suppose when we talk about disparities in availability and access to restorative justice programmes, that's what what we're referring to as well. It's about access to that, both for the person who's caused the harm, but also victims as well.
So your concern is around, I suppose, paths to restorative justice being narrowed, actually, rather than expanded.
Yeah, it's to make sure that it's. We're supportive of the accreditation and the framework and the governance and the resourcing of that, but it has to be done in a consistent fashion. And as Rachel said, that both the person who's caused the harm and the victim also get free access to it. So. But also there will be a requirement for criminal justice agencies to be supported through this, because it is different and it is out with potentially normal operations. So, as I said, you know, we support the DOJ and what they're trying to do, but would hope that what's contained in the bill will facilitate the department to take forward their plans.
Thank you. Same summary of key recommendations there. Number 5 about expanding filtering eligibility. Have you covered that, or is there anything else you want to flag up to us on that?
Do you want to say anything?
Yeah, so we welcome the proposed amendments to filtering by simplifying the list of filterable offences into the new schedule, but there are certain offences that maybe we would like to see considered to be added to the filtered offences list, like we had discussed already, the possession of drugs, particularly for young people. All drug offences here are specified offences, so they're not eligible for automatic filtering. That's different to England and Wales and their filtering process. They do filter drug possession and some supply offences from their standard and enhanced DBS checks, but we don't do that here. I do work with youth justice a lot, and a lot of the young people coming through maybe have been found with a joint, for instance, or a couple of tablets, maybe at a festival. That's going on to affect their lives further down the line. In particular, young people, even adults who want to go into careers in regulated activity. So the current filtering rules as they stand, whilst they are very effective, they're further penalising people who want to go into those types of roles. So if you get an enhanced access NI check to, say, become a teacher, or maybe you want to go into nursing and you've got an offence that is specified that isn't eligible for automatic filtering, then that can cause issues for you. We find in particular it does penalise the young people, but also a lot of our female clients are finding issues with that, not to gender stereotype, but a lot of our female clients maybe want to go into careers in nursing, medicine, teaching, those kinds of things, and this is becoming an issue for that. So we would like to see the list of filterable offences expanded to include things like that as well. But we obviously would not taking away from public safety and having things assessed on a case-by-case basis is obviously, you know, we would be supportive of that. But there are certainly certain offences maybe on that list that we would like to be reconsidered.
Thank you. Could I ask if you would look at, for members, it's page 60. For you, it's going to be 7.7 youth custody and supervision orders. In the second paragraph there, you raised the issue about those the small number of children who are going to reach their 18th birthday whilst under a youth and supervision order, and for whom it may not be in their best interest to be transferred to Hydebank Wood, especially given the short length of their sentence left to serve in custody. And you've asked for flexibility, and on the basis of that, I raised this issue with Probation Board as well to see what their view on it was. Do you have have you seen that people have been moved and it has destabilised them and destabilised their progress? I mean, I absolutely understand the common sense approach that you're taking there. I'm wondering where you think the cut-off point might be, and you know, have you seen destabilisation as people have been moved?
So I suppose the numbers are very, very small,
yes,
that we're talking about here, and you know, and Probation do work really closely with the Youth Justice Agency, which is fantastic. They do work really tightly together to look at these cases. But I suppose that you're trying to balance that, you know, with if you do agree to extend and allow that young person to finish off their order within the Juvenile Justice Centre, then I suppose from an operational perspective for the Youth Justice Agency, that means that they are housing and holding and looking after then an adult, you know, and with other vulnerable young people. I mean, our view, I suppose, is that, you know, the Juvenile Justice Centre is not at full capacity and hasn't been and hopefully will not be. There's quite a lot of space in there. I think it is possible and it's doable. I mean, Hydebank, again, our Young Offender Centre, you know, are fantastic. They're very trauma-informed, you know, prison officers and staff who are working there in order to support, you know, those very young 18-year-olds who they're receiving into their care. Don't question that at all. But I suppose our view would be that, you know, we would be taking the lead from both the Youth Justice Agency practitioners who have been looking after and caring for that young person, so they'll know, you know, best interests of the child again. You know, is this a young person they're looking after who has, you know, I suppose maybe a learning difficulty, special educational needs, has been care experienced. If they've got a month or 2 months left in order to finish out their sentence in the centre, is that manageable? Is it safe to do so? Who are the other young people there who might be impacted as a result of that? So I suppose we would be looking to you know, a person-centred, I suppose, you know, approach in order to assess those cases. I mean, I suppose we ourselves obviously don't work directly with young people in either of those settings, so I can't give you a case example or talk to that in relation to, you know, us seeing the impact on that on young people. But it's something that we would like consideration to be given to, that there be scope there to allow for that if it was so needed.
Yeah, no, it's useful to hear you expand on that and kind of give us some concept of your thinking on that. Does anybody have anything further? No? There's a couple of things if I could ask the committee. I think that we should be at that paragraph, let me see, page 39, kind of recommendation 11. I think we need, that's around the use of fines as a disposal for under 16s. I think we should be seeking clarification from the department on that and seeking their views on that. Yeah. I'd also like to query with the department, let me see, page 58 and the last paragraph there, which is around the biometrics and the retention of biometrics about around cautions and disposals. I'd like to clarify that with the department and get their thinking on that. And also this issue about flexibility around hide bank. Let me see if there's anything else I thought we should. Yes, a couple of those issues as discussed around England and Wales. Just to see if the department's thinking has changed or if they've given any further consideration. Would members be agreed to that?
All around the filtering as well was raised.
Yeah. I'm trying to read my own writing because I was writing stuff down in the course, but now I can't.
Has there been any movement or change in relation to expanding the filtering?
Yeah, and also I think we need to be asking, I mean, if they're going to put in a review mechanism, to have some understanding of why it may not be possible to do it in this mandate. Have they looked at the possibility of doing it in this mandate? You know, just to see, because you know, obviously there are people there. I mean, I can see the issues that you're having, and I think we all want circumstances where, look, you want to give people the best chance of restarting their lives, but most importantly not reoffending. That's in their interests, it's in society's interests, and people being able to have a job and make something of their lives and feel that their life is of value and, you know, they can succeed is a key part of that. So yeah, I think there's some stuff there that we should be just querying further with the department. So nobody has anything further for Niakro? No?
Nope.
Ladies, thank you very much. It's been very helpful to have you in. If anything else occurs or we've anything further as we move through these aspects of the bill, I presume you're content for us to be in touch with you again?
We're happy to come back if required, or to, you know, provide any supplementary information that you might need, and we really appreciate the opportunity to come and talk about the rehabilitation of offenders in particular, and MACR, because they're very important to us as an organisation. So thank you so much.
No, that's great. Thank you very much indeed for your time. All the very best. Thank you. So members agreed we'll send on those queries, yes?
Yeah.
Right, thank you. Let me see where we are. There's a couple of things in the next item too. Is Keir leaving the room? That's okay, because we'd be in court if you did that. Oh no, we're all right. Right, agenda items, it's just if one of them drops out, we're in trouble, and they've been in and out kind of. Right, agenda item 6 is the Justice Bill raised papers. The, let's see, page 69 to 131 in the pack. Just a reminder that the Minister plans to table amendments to the Justice Bill on restorative justice and the rehabilitation of offenders. Raise has prepared 2 papers providing overviews of the proposed amendments. Are you content to note those papers, or do you have any further information or clarification you want to raise? Can I just, before I bring Deirdre in, I would propose that there are lists of questions in those papers, and I think that we should be sending those questions on to the department. Would members be content with that?
Yep.
Thank you. Deirdre?
Yeah, Joanne, I was going to make that point, so agree with that. Thanks. And the other issue was, it might have been done in the Niakro, winding up bit, but just around asking the department why there's a different approach in between here and England and Wales in terms of the rehabilitation issues that were raised. So I'm not sure, sorry, if that was raised in terms of an action under the Niakro bit. And then the other bit was around the restorative practices around, could we ask the department what the remit of the interim protocol lead is? And again, also the issue of a time frame for the production of the practice standards and accreditation framework.
Yes, the England Wales stuff is covered, but we'll, if members are agreed, which I presume they are, members agreed that we add on the other bits there about the IPL, timeframes, etc. Yes?
Yep.
Thank you. All right, Deirdre, that's it covered in. Let me see. Right, so that's item 6 covered. Item 7 then is written papers regarding the Justice Bill. 7.1 is legislative provision for a deep fake offence, and I would ask members to turn to pages 133 to 136 of the pack where you'll find the relevant papers. At our meeting on the 10th of April, we agreed that we were content in principle for a legislative provision for a deep fake offence to be brought forward as an amendment to the Justice Bill. We also agreed at that meeting to ask the Department to set out clear timescales for the consultation process and the drafting, and that departmental officials provide oral evidence on the draft consultation prior to its launch. So the Department has suggested the 26th of June for an oral briefing on the scope of the proposals prior to the finalisation of the consultation paper. They also state that an extended consultation period of 10 weeks is proposed, as the consultation will be held over the summer period. So that would take us to, if that were, say that started in July, that would take us probably to mid-September. Are members content that we would schedule an oral evidence session in the forward work programme? And do you have any other comments you want to make on that? So we're agreed that we can go ahead and schedule that session, yeah? Right, thank you. Item 7.2 is request for further information. I would ask members to turn to page 137 through to 158 of the pack. So the team has collated a list of the committee's requests for information on the Justice Bill and the responses we've received to date. This is going to be updated on a weekly basis, as you know, and will be included in the pack. Are you content to note that?
Yeah, just to say, Chair, I think that's really helpful. To be honest, we're getting a lot of organisations coming in, and a lot of the information. We're sending lots of correspondence to the department. I was very much losing track of it as well, I'll be honest. So I think that's really, really helpful. And a lot of organisations I've noticed and are raising the same sort of issues again and again. So are we making sure just on your end we're not duplicating correspondence, and make sure we're kind of being as concise as possible, and then when it comes back to us we've got the answers we need?
Through you, Chair. I think to be fair to the committee, you do keep a good track of what's been asked before, and normally if you're asking about an issue again, it's an extension of what you've asked before. It's not the same stuff again and again.
That's grand.
So, yeah.
That's really helpful. Thank you.
Okay, agenda item 8 then is the police and criminal evidence order. It's PACE. You'll know that the Deputy Chairperson had requested the consideration of this item be deferred until a later date on the committee's work programme. And given the significant volume of papers for this item, the clerk had emailed everybody yesterday to provide advance notice of the potential deferment to assist with preparation for today's meeting. Can I ask, first of all, that you're content to defer that for now? I think that we need to have a further discussion around the Deputy Chairperson. Deirdre, you'd specified that your preference was the 22nd of May. There may be some issues around the 22nd of May because the workload, the forward work programme isn't fully up to date. It's been slightly changed since it was issued, which means that the 22nd of May could be fairly horrific. And it may be better to move that to the 15th of May. Just look, I'm conscious that there's a lot of stuff coming in front of us. None of it is kind of light and easy, and I'd rather we did things properly. But there's a lot of preparation goes in, and if you've got a pack that's 2,000 pages one week and 300 pages the week before, I think it's not just about the length of the meeting, it's about the preparation time and the work that goes into that. So I kind of want to make sure that everybody's got a reasonable balance from week to week. Deirdre, you want to come in on that?
Yeah, no, and it was just to say thanks, and I suppose just to the clerk team. And really, I mean, sure, it's for that reason that I was looking at the 22nd of May. I mean, I completely understand and recognise that we have a busy schedule on that day, and whether there would be any flexibility to either meet, 20 minutes before to deal with this issue. It's just to give myself a bit more time on this, and I would just be concerned that next week doesn't do that. And I can understand the points you've made, but I suppose I don't often ask for flexibility, and I'm just asking in this case because obviously I understand the department want to lay these early June, and I want to keep with that timetable. But I would, if there's a possibility of doing it on the 22nd, and to be flexible with the time and also stringent in terms of our speaking time on that day, if there's the possibility or the flexibility of the committee to grant that request.
Deirdre, the issue is the extent of the agenda. I think we've got two or three oral briefings that day.
Chair, we have the legal briefing on restorative justice that was in for next week is moving to the 22nd, so that means there are 2 amendments being covered by Simon on the 22nd. So the restorative justice and rehabilitation amendments, there's legal advice on both of those, and then there's the beginning of the domestic abuse that the committee wanted to look at, which includes post-legislative scrutiny, and that's an oral briefing with the department. So those are the 2 oral sessions. One's obviously closed, and then we have 2 written papers there, deaths abroad and enabling access to justice update.
So they're not small items. The issue with the 29th was, because I thought, okay, well, if it's more time you're looking for, let's look at the 29th. And Cathy and I had a fairly lengthy discussion about this earlier today. The 29th is also a bit of a struggle, isn't it?
Yes, because the department, the LCM, the Border Security and Asylum Bill, I might have got that slightly wrong. The oral evidence that the committee has requested on that is, the department has suggested the 29th for that, so that's going to go in there. As well, and there again are 2 written papers that day, and then there's an oral evidence session with Sajini.
Deirdre, do you anticipate that you've got a lot of queries for the department on this? I mean, there's some issues that I have with regard to pace, and how it ties into the bill. I'm fairly sure we got correspondence that indicated that as a result of the bill, a lot of the pace codes are going to have to be revised anyway because of the retention periods and so on. So I don't think this is our last bite at pace, let me put it that way. But are you concerned? I mean, do you have a lot of stuff that you need to raise?
Yeah, it's the time, yeah. Just my only concern is next week. And if I haven't got everything ready, pushing it back again, and I'm conscious of that deadline in June.
Yeah.
And I suppose just with a series of pace, Joanne, they are big issues, that play out within our communities at the moment. So I completely understand the workload, and I don't even know around some of those briefings, not the oral briefings. I mean, I get that on the 22nd, but even if there is any flexibility of meeting a bit earlier, I would be up for that.
Deirdre, my concern is not the kind of meeting earlier. We've done that previously. The issue is the extent of what's already on the agenda and the amount of papers that there are, because whatever there is, if it's a sizable number of papers, pace is 600-700 pages. And that's what my fear is. So we were kind of lighter on the 15th. So I was trying to balance, the amount of work that we're going to have to put in on each week. So there's extra time, but actually the pack for the 22nd is likely to be fairly horrific before you put pace in.
Can I make a suggestion, Chair? And I really don't do this lightly because I think it's an important issue. But the post-legislative scrutiny that's in there, it feels like it could probably be shifted given there's a deadline. Is that for the 22nd? There's post-legislative scrutiny. That feels like something that, given its post-legislative scrutiny, could it be shifted for a few weeks? And then the pace, because it has a deadline upcoming within the next few weeks, could it be that be used to accommodate extra time?
Did we ask for that, or did they?
The committee asked for a general, this is the beginning. I think it was around maybe early March time that the committee decided it wanted to look at more in depth at domestic abuse and all those issues, surrounding it. And one of the issues is obviously, I think that came in the back of a written briefing from the department on part 1. And the Sagini report on part 1 was in last week's pack as well, of the domestic abuse. So it's actually slightly broader than just the post-legislative scrutiny. It is, but there's also the domestic and sexual violence strategy. The update on it will come later. So this was the start of the committee starting to look at the issue of domestic abuse.
An issue I'm really interested in, but I think just to have capacity in this, I think.
I agree. I think that's fair.
We need
Want to do that?
Yeah.
Yeah. Look, if the committee's agreed, I think
There's pressing deadlines on one thing.
Yep.
And we need to take the time because it is.
Yeah, the pay stuff needs to
It needs to
progress, and that's why I was right. So, is everybody happy enough with that?
Yeah.
Deirdre, are you content with that?
Yes, and just to say thank you, I really appreciate it. Just for making the flexibility. So thank you.
No, look, it's a serious issue. The issue just is trying to balance the workload to make sure that because the more you shove in there and the bigger it is, the more scant the reading, because you just can't, So I just want to be clear that we've got. Does that work for you guys? You can try and we'll make the request to the department and see.
Yeah, I'll contact the department. We'll if it suits the committee, we'll maybe try and reschedule it for June then, at some point. But try and get it in before the summer recess to at least begin that piece of work.
Yeah, that'll be helpful.
Kathy, I look forward to the day that you only give us a 300-pager.
If ever.
I recall opening the pack a few months ago and getting 2,000, 3,000. It was 2,800
I
one
have
day.
not done that.
I
I'll point that out. I haven't done that. 1,200 is the most so far.
Yeah. Pace codes. Fun. Right. Agenda item 9 is amendments to legal aid remuneration, outcome of consultation and way forward, and there's a written paper from the department. You'll find this at page 776 to 798 of the pack. Members, the department has provided a written paper and the post-consultation report on the proposed amendments to legal aid remuneration. Are you content to note that paper and post-consultation report, or do you require any further information or clarification? Content to note?
Yeah.
Do you require anything further? Because if you do, it's going to have an impact on the next 3 ASL ones. So everybody's good so far?
Yeah.
Right, thank you. Agenda item 10 then is ASL 1, the Civil Legal Services Remuneration Order, Northern Ireland 2025. So the next 3 items of business are linked. It's all statutory rules that relate to legal aid remuneration, and it would give effect to the ministerial decisions that were announced on the 2nd of December 2024 regarding the Enabling Access to Justice Reform Programme. You'll see the clerk's memo at page 800 to 802, and that covers all 3 proposals for the statutory rules. The first proposal you can find at 799 to 841. The Department is proposing to bring forward a statutory rule under powers conferred by the Access to Justice Northern Ireland 2003, I presume that's order. The purpose of the rule is to replace the Civil Legal Services Remuneration Order Northern Ireland 2015 and to make provision for the following changes. So it's a general uplift of 16% to legal aid fees in respect of most civil legal services, enhanced remuneration for PACE and parole matters above the level of general 16% uplift, enhanced travel, waiting and mileage rates, a revised remuneration model in respect of immigration and asylum matters, amend the lower and upper thresholds for interim payment of disbursements and remove the requirement for a disbursement to be discharged before payment. The proposed rule will be subject to the negative resolution procedure. Are members content with that rule, or do you require any further information or clarification? Content with the rule?
Yep.
Agenda item 11 then is another SL1. Same vein, the Magistrates Court and County Court Appeals Criminal Legal Aid Cost Amendment Rules Northern Ireland 2025, and this is pages 842 to 852. The Department is proposed to bring forward a statutory rule under powers conferred by Legal Aid, Advice and Assistance Northern Ireland Order 1981. The purpose of the rule is to amend the Magistrates Court and County Court Appeals Criminal Legal Aid Cost Rules Northern Ireland 2009 to make provision for the following changes. general uplift of 16% to legal aid fees in magistrates' court criminal cases and county court appeals, provision for indictable only youth cases at the youth court to be remunerated by way of the 2005 Crown Court fees, and for indictable only youth cases heard on appeal in the county court to be remunerated by way of an enhanced fee and enhanced travel rates. It's proposed the rule again would be subject to the negative resolution procedure. Are members content with the rule, or do you have any further information or clarification you require? Content? Thank you. No, I mean, I appreciate with all of these, we've had it on the floor of the Assembly, we've had statements, we've had updates from the profession and so on, so we're all fairly au fait with the implications of this. Agenda item 12 is the last SL1 on this, which is the Legal Aid for Crown Court Proceedings Cost Amendment Rules Northern Ireland 2025, and that's page 853 to 871. Again, the Department is proposing to bring forward a statutory rule under powers conferred by the Legal Aid Advice and Assistance Northern Ireland Order 1981. The purpose of the rule is to amend the Legal Aid for Crown Court Proceedings Cost Rules Northern Ireland 2005 to make provision for the following changes: general uplift of 16% to legal aid fees in the Crown Court, provision for indictable only offences at the Youth Court to be remunerated by way of the 2005 rules, enhanced travel rates, and amend the upper and lower thresholds for interim payment of disbursements and remove the requirement for a disbursement to be discharged before payment. The proposed rule will be subject to the negative resolution procedure, just like the previous two. Are members content with the rule, or do you have any further information or clarification you require? Members content?
Content, yeah.
Agreed. Thank you very much. Agenda item 13 is the Victims and Witnesses Bill and the outcome of the consultation and draft legislative proposals. And again, it's a written paper from the department. You can find that at page 872 to 988 of the pack. The department has provided the report of the outcome of its consultation on proposals to enhance the support and representation of victims and witnesses within the criminal justice system, and that's going to inform the Victims and Witnesses Bill that the department's intending to bring forward later in the mandate. They've advised us that the post-consultation report is going to be published once agreed by the committee, and the executive's approval for the bill content will be sought. Are members content to note the report and the associated papers for the department to publish the report, or do you have any further information or clarification you require? Remember, I suppose the only question that I have on this is fairly grave issues, and it would be interesting to see how the outcomes of this and where the department's going with the bill tie in with the Victims and Witnesses strategy, which is our next agenda item. There's an opportunity, and it's not unusual for us to do pre-legislative scrutiny on some of these things, and we don't have to schedule it for now. We could have an oral briefing maybe in September, October on some of these issues. Would you like to have an oral briefing on some of this? Yeah? Okay, well, we'll schedule that in then later in the year. That takes us to agenda item 14, which is the Victims and Witness Strategy 2025 to 2030. I'd refer members to pages 989 to 1068 of the meeting pack for the relevant papers. The department has advised that following a call for views exercised in October 2024, it plans to consult on a draft Victims and Witness Strategy 2025 to 2030. The strategy is around 5 pillars, which are support, communication, information, transparency and participation, rights and confidence in justice, and children and young people. Subject to any issues raised by the committee, the department aims to publish the consultation in May, and it will run for a period of 10 weeks. Are you content to note the papers and consider the matter further when the results of the consultation and the way forward are available, or do you require any further information or clarification? Yeah, that's fair enough. I suppose there's a couple of things that, as we get to the oral briefing session, there's a couple of things that I want to check around. Okay, well, how does the new strategy relate to the appointment of a commissioner, and where does it leave the commissioner, because they'll be coming into place whenever there's a strategy already there, and yet we're told that they're going to determine their own priorities. So how will this work going forward for them? I also note that within the bill there's prioritisation of vulnerable groups, and yet in the foreword of the consultation the Minister says evidence tells us that the impact of crime transcends boundaries of gender, age, sexual orientation and ethnicity. And I think that that's fair. If you're a victim of crime, you know, it's fairly traumatic, and there may be different barriers if you're in a vulnerable group, but I think I'd like to just explore some of that a bit further and see what the intention is. I also want to make sure that if they're, you know, looking at the role of the Commissioner, I don't want us in circumstances where, again, the Assembly struggles for accountability mechanisms and understanding how it works and how you can raise queries. And we've seen some of that in this committee, for example, with the Ombudsman's Office, where people aren't clear. I appreciate that this Commissioner will be subject to NIPSO, but just to understand, you know, how some of this is going to work out. So I think it'll be helpful to explore some of those issues in the oral briefing. So, okay. That takes us to item 15, which is correspondence. There's a correspondence memo and 18 items of correspondence going from page 1071 to 1193. I'm going to draw your attention to a number of the items, as I usually do, and then I'll open the floor so that you've got an opportunity to comment on any other items in which you've got a particular interest. Deirdre, I'm going to flag up a couple of things and then I'll bring you in, or is it on the is it on the previous item?
Yeah, no, that's fine, sure, thank you.
It's on correspondence, yeah?
Oh,
Yeah.
yes, sorry, correspondence,
Okay,
yeah.
that's fair. Okay. Item 15.2 to 15.5, I'd ask members to turn to page 1074 to 1088. At our meeting on the 3rd of April, we considered the Sejeni report and inspection of the Police Ombudsman for Northern Ireland's investigation of abusive position, concerns and complaints. And the report made a number of recommendations for the Department of Justice, the Office of the Police Ombudsman for Northern Ireland, the PPS and the PSNI. And the committee wrote to each of those organisations to ask whether they accepted Sejeni's recommendations, and those responses have now been received. Are you content to note the responses at this stage and seek further updates on progress to implement the recommendations at a later date, or do you require any further information at this stage? I would flag up that the Police Ombudsman's Office has offered to brief us on some of these issues, which may be useful, and I can see how in some respects it applies, but I just want to be very careful that we're not stepping into the remit of the Policing Board, because stats around police misconduct and issues around police misconduct are dealt with at the board. So I want to be very clear what the parameters are, although they have particularly highlighted issues with regard to strategy and so on. So I don't know whether members want to take up that offer or how you want to proceed.
Sure.
Deirdre?
Sorry, yes, no, this was one of the areas of correspondence I was going to raise, and I would be keen to take up that offer, because as you say, even in terms of just meeting with the policing, meeting with the Ombudsman's Office, and I think it was an interesting letter. It was a point that I had raised with the Minister in terms of the Home Office at Westminster bringing through changes, you know, and I was keen to see what work's being done here, and I think on the back of the Sejeni report, and I suppose the contents of the letter, I would be keen, you know, to accept their offer of a meeting. I'm not sure even if we need to meet the PPS and stuff in terms of some of the information that they put in their correspondence as well, but I don't think it would harm us in meeting with the Police Ombudsman Office.
Yep, that's fair enough. Are we content to maybe schedule that after the summer? I'm also conscious that the Ombudsman referred to a number of statistics about police abuse of power issues and so on around sexual offences and that kind of thing, and yet similarly we've got correspondence coming in from the Chief Constable on the same issue, indicating that HMIC has inspected them and found them to be good in this area. So yep, so members content to schedule this for after the summer recess at some point?
Yep.
Thank you. Item 15.7 is correspondence from the DOJ at page 1093, and it's a response to our request for their views on a number of issues raised by Relatives for Justice regarding the Troubles Permanent Disablement Payment Scheme. Can I seek your agreement to forward that response to Relatives for Justice and the Committee for the Executive Office, please? Yep. Item 15.9 is correspondence from... Do you want in that particular item?
It was on that, yeah, the two items I was going to read. Sorry, no, and again, just thanks to the Minister for a reply to that. I suppose I had one query, or maybe just to note that I would have a concern in terms of the assessments that are being done by Capita, where I'm hearing some information that people are being asked to strip down, even though their medical records are there in terms of their injuries. But I would be willing to, Joanne, as it says in the paper, you know, that the TEO committee are going to be taking evidence. So I would be keen on the back of not just sending this letter to them, but also if we can get an update then from that oral session, and if there are any issues that are pertaining or fall under the responsibility of the Justice Department, particularly around Capita and the assessments, that we would get an update after that hearing on the 17th, if that was okay. Thanks.
Yeah, certainly I would support that. I mean, I have also received testimony from people who have been completely re-traumatised by their interview. And it has led to them having a significant downward spiral in their lives, and it's been massively to their detriment. And I don't think that that was what was envisaged. The aim here was to help people who had been through horrific things. So if we can correspond with the Committee for TEO on those issues to see what Capita is doing with regard to how they're handling the re-traumatisation of people who've been through this. I anticipate that TEO would be asking questions around timeframes, because I've had a number of cases where a cursory Google search would indicate that the person was at the scene of a horrific incident. I'm not going to get into the specifics. And that their injuries were huge and unthinkable. And yet it took a considerable period. And more than that, they received correspondence to indicate that were they to chase up where they were in the process, or indeed have an elected representative chase up where they were in the process, it would result in further delays and potentially them being moved to the back of the queue. So none of this strikes me as what was envisaged by this, or that in practice there is compassion for those who've been through some of the most horrific things in our history. So would members be content that we flag those issues up to the Committee for TEO for them to take when they're taking evidence, and we can then ask them to respond back to us, so what they get, or maybe provide us with the Hansard of that? Yes, members agreed?
And I would just reinforce the time frames. I've just had a conversation with another MLA, and they've had a good few cases as well, and really these people are saying they'll be long gone before there's ever decisions made, even though, as you say, they've experienced horrific events and injuries, but it's just so long drawn out. So
Yep, I think there's 7 stages, but like it's taken years and years. And I understand they've got to do their due diligence and ensure people are there.
Yeah.
But there are ways and means, and I think certainly the re-traumatisation of people. And some of that may well be inevitable, but the handling of it is key, and being as sensitive as you can with people. So I think we need some reassurances around those issues. Let me see where I am. Right, they're still in correspondence, and it's item 15.9. Again, correspondence from DOJ, page 1101, which is response to the Committee for the Executive Office request for information regarding the Department's role in funding and activities related to the Ending Violence Against Women and Girls strategy. Are you agreed that we can send on that response to the Committee for the Executive Office? Agreed, thank you. Item 15.11 is correspondence from the Department at page 1107, and it's a response to our request for its views on a written paper from Retail NI. Can I have your agreement to forward the response to Retail NI, the Committee for Finance and the Committee for the Economy for information? Great, thank you. Item 15.6 is correspondence from an individual at page 1167 of the pack, and it's regarding an individual complaint about the Lady Chief Justice and health trusts. Members, you'll note that that correspondence has been marked restricted because it contains allegations against named individuals. Can I seek your views on how you wish to handle that? If you have any thoughts on it. There's a similar item, which is item 15.17, which contains complaints about family courts and health trusts. On the second one, it seems to me that we have already agreed that we will undertake a piece of work in terms of how these types of issues are handled in the family courts. We've already had a meeting with the Lady Chief Justice and some of the judges from that court, and we've raised some concerns and sought some clarification. And we did so on the basis of process points and not specific cases. And this is where the difficulty comes, that whilst we have enormous sympathy and empathy for people who find themselves in this position and who are concerned about how they're being treated in the courts, we can deal with the policy and the strategy and the processes, but I'm not sure it's for the committee to take on individual cases. So we have a role in strategy, policy and legislation with justice matters, and we have engaged with the Lady Chief Justice and actually the Minister too on some of these issues. But the problem here is it's individual complaints. Now, I do note that in the course of this, you can see at the top of the emails, correspondence has also been copied to others, and they may well be better placed to assist, or the individuals may wish to contact their local representatives. But I think that we can look at the big picture. But
yeah, I think if you open up the complaints, you could end up with an awful lot of complaints coming through the committee if you start looking at one.
yeah, and I think that we can deal with systematic issues. But I think we're in a tricky position with this one, but I don't want to leave these people without at least signposting them to places.
That would be my point, not
Yeah.
leaving these people whereby they can send it out everywhere because they don't actually are clear what's the pathway given their case, because it can be so complex and they have liaised with so many different agencies and probably maybe frustrated in different levels. Where can they easily place their story?
The first one is difficult in that there are timescales involved, and it has been indicated that the timescales have passed, but that's not how that person feels about it. Although I note that actually I think we're copied into that, it's not to us, but there are other people involved in that who are much better placed to redirect, and I think that we can say, look, we note, and we're going to look into the bigger issues. But with regard to your case, there's other people on the list that you've already contacted, and also you may want to contact your local representatives.
Do you want to raise their hope, Taylor?
No, it's very difficult, and and when people are writing to the Committee for Justice, clearly they feel very strongly and they've been through the mill, and it's very difficult, and I don't want to be insensitive to it either. But we're kind of restricted and limited in what we can do. Deirdre, you had your hand up there.
Yeah, Chair, suppose it was the same as a previous issue, where there was correspondence, and obviously we got the legal advice as well from Frank and Co. So I'm not sure if there's an avenue there, or as you say, is there another pathway that we can give some of the individuals then, where the complaint can be appropriately registered. And as you say, if there are thematic issues, obviously we're already alerted to the issues that are highlighted. We've done an initial meeting, we've discussed it today in a previous item that we are going to come back to. But it's just if there are individual complaint issues, then just making sure we're directing them in the appropriate way, Yeah.
Well, certainly the first letter we've received, that person has kind of there are other people in that email included. The second one, let me just check. No, the second one does not, and I think we probably do need to highlight that there are the other places that are available, and that probably can be done through looking at the previous case.
Whoops. Second one
Second one's a letter.
from is that the address at the top?
Mm-hmm.
It did actually go.
Did it?
Yeah, it went directly to a lot of members. In fact, I think it went directly to all members. It went to the Victims Commissioner, went to the Minister's office, and then the public email here. So it did go to other places too.
But there may be other places in the system, which may be, we might be able to find out from the previous email. You know, where that has gone to. That might be able to help the second complainant there. I don't want to get into people's names.
Yeah.
But there's some overlap with the issues.
I think just as long as, you know, we can explain to them that we don't deal with complaints, you know, again, that they're making, but we understand the wider issues and maybe outline some work we have done and are conscious of, just so they don't feel like we're
We're continuing to do, because we're not
like
finished with the subject.
Like don't want them to feel like we're trying to pan them off, but there are obviously limits in what we can do as a committee.
Obviously very sensitive issues where people are having access to their children and issues like that. So better members agreed with that means of progress then? Yeah, thank you. So through with them. So then 15.18 is an invitation from Legal Futures Research to a conference on the subject of data in public and commercial realms. If you're going to go to that or you have interest in that, please contact the people directly using the email address that's in the correspondence. Similarly, item 15.19 is an invitation from the Lady Chief Justice's Office to a lecture at Ulster University on sentencing practice in Northern Ireland. And again, members should respond directly using the email address in the correspondence if they wish to attend. Are you content to note the other items of correspondence, or do you have any comments you want to make on them? Deirdre, I know you had indicated, but are your subjects covered, or have you anything else?
Yeah, they were covered already, Stuart. Thanks.
Okay, and I don't think I had anything else either. Right, so we'll move on. Agenda item 16 is the forward work programme, which to some extent we've already covered, and what you have in front of you is not the updated position. But anyway, I would ask you to turn to page 1195. There's a proposal from the department to schedule the oral evidence session requested by the committee on the proposed legislative consent memorandum for the Border Security, Asylum and Immigration Bill on the 29th of May. Are you content to schedule that for the 29th? And then obviously you've got the draft in there. It's not up to date and we do need to do some more work on that, but are you content to note that and subject to various changes, and we'll try and be as practical as we can with that, yeah? Great, thank you. Chairperson's business, there is none. Does anybody have any other business? No. Date and time, place of next meeting is this room on Thursday the 15th of May at 2 p.m. That's it, members, the meeting's adjourned. Thank you.
Committee Room 30, sound. 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 Committee Room 30. 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 Sound.